Welcome, everyone. It appears that Jose Maria de Castro, aka Delete Laws, aka Chili, is adding to his lawsuit with yet another complaint. However, this complaint is about copyright infringement, and it's about him shutting people down and shutting people up instead of copyright infringement. And I highly doubt the judge will even consider this complaint because it is about copyright infringement, which has nothing to do with his defamation case. But let's get into it and see just what he ignores regarding copyright laws. So this is against Joshua Abrams, Kate Peter, and John Doe's 1 through 50. So he is basically targeting anybody that showed any bit of his videos whatsoever. It reads, Plaintiff Jose de Castro brings this complaint against YouTube publishers Joshua Abrams, Kate Peter, and John Doe's 1 through 50 and alleges as follows. 1. This is a case about the ongoing and wholesale copyright infringement of my video content by defendants Peter, Abrams, and others currently known only by their YouTube channel name or URL. 2. I teach constitutional law and am attempting to tear down some of the racist laws in the country, which invites hate and offers opportunity to those that profit on hate. Of course, it's the old, I'm doing something good for people in this country and the haters don't like it, lame excuse. Those of us that cover Chili know that is not the case. But Chili keeps perpetuating that he's the victim here, even though on every single live stream he does, he actually defames and bullies people. 3. As part of my teaching and as a revenue stream, I create video content and publish it on YouTube. Yes, there are a lot of us that create video content on YouTube. Video content does not have to be original content from each individual content creator. But we'll get into a little bit of this a little bit more in this filing because he does go into copyright laws. 4. Defendants, to save from having to create content themselves, are, in a word, stealing my content on a grand scale. Not stealing, it's called fair use, Chili. They publish content to YouTube that largely only copies my content for monetary gain in the same YouTube content market and without my consent. Again, fair use, Chili. When a channel's monetized, you're allowed to join the YouTube partnership program and get ad revenue. Of course, our cut is pennies on the dollar compared to the cut YouTube gets for allowing us to use its platform to show these videos. Even Chili gets ad revenue from videos where he uses other people's content. 5. This is a civil action seeking damages under the United States Copyright Act of 1976, as amended 17 U.S. Code subsection 101 et sec, the Copyright Act, and the Racketeer Influenced and Corporate Organizations Act, RICO. He brings up a few sections of the Copyright Act, so we'll go through those per section. But this RICO Act idea that he can't get out of his head because he thinks Kate is the head of this mafia shows how delusional he is. It also shows that he doesn't get irony very well. Jurisdiction and venue. 6. This district has subject matter jurisdiction over this action pursuant to 28 U.S. Code subsection 1331, federal question, and 28 U.S. Code subsection 1338, jurisdiction over copyright actions. 7. This district has personal jurisdiction over all defendants under the Criminal Copyright Act predicate 2319 of 18 U.S. Code subsection 1965, RICO. RICO violations make up the majority of the factors in the claim in this action. Yes, it's a federal district. It deals with criminal and civil cases. However, Chili's case is against Kate and Josh and whoever et al. Are, which is a civil case. RICO, however, is criminal. Chili's just throwing any U.S. code on the wall and seeing if it sticks. 8. Pursuant to 18 U.S. Code subsection 1965A, venue is proper in this case because it sits in a district that defendant Peter resides. Pursuant to 18 U.S. Code subsection 1965B, a court that is proper for one RICO defendant is proper for all other RICO defendants. Oh, Chili, Chili, Chili. Oh my God, you are such an idiot. He has successfully broken in half and is now deep underwater in the ocean of his own making with his delusions. The other parts of this are just the parties and their addresses, which I'm redacting. I know it's public and can be seen, but I'm not going to put their addresses out on my channel on YouTube. Factual background. 13. I have published over 800 videos to which I own the valid copyright to as content on my YouTube channel and then his channel URL. 14. I earn revenue when those videos are viewed directly from my YouTube channel. 15. Defendant YouTube publishers have copied large portions of my copyrighted content on their YouTube channels. Copied means that we would take Chili's videos and just put them on our channel with nothing overlaid, no comment, no criticism, nothing. However, that is not the case. 16. Many of the defendants make money from copying my content onto their YouTube channels when my content is viewed on their channels. Again, we don't copy your content. We take it, we download it, we add commentary, criticism, parody, whatever, and make it fall under fair use, and we monetize that video. Chili has done the same with others' videos, yet it's okay for he, but not for thee. 17. All the defendants are in the same market of YouTube content creation. 18. Defendants profit from my content simply by using it to save them time and money and the effort of creating their own content. Nope, not how it works. Again, we don't have to create our own original content. Fair use applies, but we'll get into that later. 19. My copyrighted works are listed in Exhibit 1 and any supplements by YouTube URL. According to the FAQ page on copyrightalliance.org, why should I register my work if copyright protection is automatic? Since copyright protection is automatic from the moment a work is created, registration is not required in order to protect your work. However, there are numerous benefits to registration and therefore it is highly recommended if feasible. These benefits include bringing an infringement action. It enables you to file a lawsuit to enforce copyright in federal court. You must file an application for registration before you can sue someone for infringing your copyright, even if the infringement has already occurred. So it seems Chili has dropped the ball yet again. Copyright infringement. 20. The allegations contained in paragraphs 1 through 19 are hereby realleged as if fully set forth herein. 21. I am the owner of the valid copyright of the works. 23. Defendants copied and distributed constituent elements of my works. 24. At no time did I authorize, permit, or consent to defendants' distribution of my works, expressly or otherwise. Under the Fair Use Act of 1976, we don't have to get permission as long as that work is transformed in some way or fashion via criticism, comment, parody, teaching, news, etc., and so forth. 25. As a result of the foregoing, defendants violated my exclusive rights to reproduce its works in copies in violation of 17 U.S. Code subsections 106.1 and 501. Subsection 106 is exclusive rights in copyrighted works. It really just goes over what is considered copyrighted works. Subsection 501 is infringement of copyright. B. Distribute copies of the works to the public by sale or other transfer of ownership or by rental, lease, or lending in violation of 17 U.S. Code subsections 106.3 and 501. This does not apply to any of us that cover Chili. No one is copying his videos, selling them, or transferring ownership of them for rental, lease, or lending. The majority of us have transformed them in some way via the Fair Use Act, thus they're not the original works nor copies. C. perform the copyrighted works in violations of 17 U.S. Code subsections 106.4 and 501 by showing the work's images in any sequence and/or by making the sounds accompanying the works audible and transmitting said performance of the work by means of a device or process to members of the public capable of receiving the display as set forth in 17 U.S. Code subsection 101's definition of perform and publicly perform, and D. Display the copyrighted works in violation of 17 U.S. Code subsections 106.5 and 501 by showing individual images of the works non-sequentially and transmitting said display of the works by means of a device or process to members of the public capable of receiving the display, as set forth in 17 U.S. Code subsection 101's definition of publicly display. In C and D, he's saying that we are infringing on his right to his image and his audio as well as the videos themselves. Again, it's called fair use. 26. Defendants' infringements are committed willfully within the meaning of 17 U.S. Code subsection 504(c)(2). The first line of that states, in a case where the copyright owner sustains the burden of proving and the court finds that infringement was committed willfully, the court in its discretion may increase the award of statutory damages to a sum of not more than $150,000. It's important to note that Chile has claimed that he's lost over $100,000 due to us using his likeness, audio, and videos. We all know that's a very high overestimation on his part. Unless you have hundreds and thousands of views on your video, your ad revenue is gonna suck. Request for relief. I respectfully request that the court A. permanently restrain defendants from continuing to infringe my works. B. Order that defendants delete and permanently remove the digital media files relating to my works from each of the computers under defendants' possession, custody, or control. C. Order that defendants delete and permanently remove the digital media files containing copies of my works that defendants have on computers under defendants' possession, custody, or control. Chile's going to have no luck where that is concerned. As this is a civil case, not criminal, not even the courts can force anyone to delete anything about Chile off of their computers. And honestly, Chile knows he's not going to get a win on this, which is why he's now attacking the Fair Use Act of 1976 and calling it outdated. However, the entirety of the U.S. copyright codes, including the Fair Use Act, is written to not be outdated, just like the U.S. Constitution. And of course, since 1976, copyright cases have been brought, as well as fair use cases, making the Fair Use Act and copyright laws relevant to the technology of today. D. Order that defendants remove all media files from YouTube containing copies of any portion of my works from YouTube. This one I could see the courts being able to enforce through contempt of court or fines. However, you must first win your case. And I highly doubt the court is going to let you lump everybody into the same copyright infringement lawsuit, or even sue us individually, since your works are not registered through the U.S. Copyright Office. E. Award plaintiff statutory damages per infringed work pursuant to 17 U.S. Code 504A and C. F. Award plaintiff its reasonable attorney's fees and costs pursuant to 17 U.S. Code 505. And G. Grant plaintiff any other and further relief this court deems just and proper. Respectfully submitted, signed Jose de Castro. And then, of course, he includes in the last 13 pages all of his video URLs as Exhibit 1. Now, I am no legal expert, but should he not have included all of the URLs he claims are infringing on his copyright within this amended complaint? Wouldn't that make sense because they would be evidence? Oh, look who we're talking about, silly me. His evidence is either they said mean words to me, or they lied about me even though later I admitted the truth, or an allegedly staged evidence video. It's really important to note that with all the copyright laws that Chile put on this complaint, nowhere was 17 U.S. Code 107, which is fair use. Will this be turned into a lawsuit? I doubt it. He has not registered his works with the U.S. Copyright Office. He cannot lump sum everybody into one class action copyright infringement lawsuit. He must file in each individual federal court jurisdiction copyright lawsuits on each individual person. And if there are those that live outside of the country, he's got to go to that country's courts to file. Chili knows nothing will come of this, but like the Energizer Bunny, he keeps going and going and going.